We live, ready to go? Okay. Great. Morning. This is Chair Albert Chang calling the meeting to order, back to order from a recess. It is now 9 o'clock in the morning on June 5th, Friday, June 5th of 2026. This is a resumption of the Oil Conservation Commission hearing that that began on June 3rd, 2026 for the deliberations and considerations on case number 24683, the Western Environmental Law Center's application for rulemaking to amend NMAX 1915-2, 1915-5, 1915-8, 1915-9, and 1915-25. I want to start with a brief recap of what we've done so far. At the last commission hearing, we organized ourselves around the various proposed rules. We walked through the applicant's post-hearing proposed amendments to the referenced provisions of the New Mexico Administrative Code. Those post-hearing proposed amendments did include incorporated changes that the applicants made to their proposals in light of negotiations that happened and in light of the changes that were reflected in the joint stipulation. And I will clarify with commissioners throughout the day that what we intended to, or what we did review were that we did crosswalk all proposed rules, and that we are aware of what the blue highlighting means, what the yellow highlighting means, what the red line strikeouts means, and that none of us are debilitatingly colorblind, and that we, in reviewing the sections one by one, we went through and adopted not necessarily the joint stipulation per se, but the applicant's post-hearing proposed amendments to the various sections of the NMAC that incorporates language from the joint stipulation. At the end of the day, we had reserved judgment on a number of provisions. And I guess I will first turn to commissioners and see whether they wish to address any broad overarching legal concerns again, or whether we're ready to dive right into the sections that at least that we had discussed reserving judgment on, or anything else from last, or anything else that we may have discussed on Wednesday that commissioners may want to revisit.
Mr. Chair, if I may, and I guess microphones are working okay? Is hearing okay? No, I'm not pressing any buttons, still strange. You got a green light in front of me. I think you addressed perhaps indirectly the NMOGA and IPNM joint motion for clarification.
I was hoping to functionally do that without taking up any motions, given that we are in the middle of deliberations. Commission counsel can correct me, but I'm not sure that it would be appropriate for us to entertain motions at this stage of deliberations.
I concur, Mr. Chair.
So I think it's okay for us to take notice of the fact that there was perhaps some parties felt that there was confusion. And so I did my best to try to clarify that on the record without officially entertaining a motion. But certainly if there's any additional clarifications or any, or if commissioners would like to further address sort of substantive housekeeping issues that were raised, I'm happy to create time for commissioners to do that. I just didn't want to make it a free-for-all for all the parties at this point in deliberations.
Sure. Yeah, I think some of the questions might have been important there. And, as I saw it on Wednesday when we previously met, previous meeting, unless otherwise noted in our deliberations, we adopted the existing rule language and any changes as indicated in the joint stipulation, which was
Well,
exhibits to the applicant's closing arguments. And so we adopted those things together and voted on them as we went. And I certainly don't feel that I need, new versions of proposed rules and our positions to finish the rulemaking. We have quite an abundance of materials in front of us.
if I make, I think there's some nomenclature that might be causing the confusion here. Because if you look at the joint stipulation table, there are parts that are in blue that reflects the joint stipulation. There are language that's merely in red line strikeout, not highlighted in blue, that reflects language outside of the stipulation that the applicants want us to consider, which is why I was trying to clarify that what we actually went through is not merely the language, merely the highlighted language, but what we actually went through was the applicant's post-hearing proposed amendments, which did reflect the joint stipulation, but is broader than the joint stipulation. I think that might have been the confusion where we kept saying that we were adopting the joint stipulation, but if we were looking at the applicant's post-hearing proposed amendments and adopting not just the highlighting the blue language, but also the red or yellow highlighted language, then what we were actually adopting was applicants complete the totality of the applicant's post-hearing proposed amendments, incorporating the smaller subset of language that is the joint stipulation, but we were adopting more than just the joint stipulation. I think that was the crux of the confusion for perhaps for some of the observers.
Sure, I think that was well put. Yeah.
Is that?
The other thing I would also just mention is I think as commissioners, we read submitted documents, closing statements, and gave them due and serious consideration throughout. And that a lot of this was homework. I mean, we, didn't come here to pour through a 10,000 page, what is probably a 10,000 page record, or even have, side by side closing arguments set up for comparison. I think I might just add that I'll leave it there for now.
And if,
Let me just say that, let me finish that.
sure.
Of course, the OCC needs some version of the existing rules and proposals to look at in our deliberations. We have to refer to something. So we had a document that we were working off of Wednesday. And I think because the applicants and OCD convinced us that there's a serious situation that we can and must address, and that the preponderance of the evidence is with the applicants and OCD's case, we took this version that was attached to the applicant's closing arguments. We use that as a reference and we compared it to the alternatives offered by NMOGA and IPA&M. Had NMOGA and IPA&M prevailed and convinced us that there wasn't something we had to take action on, or it wasn't the right course, I don't think we'd be referencing the applicant's closing arguments and the what we've been provided there, a version of the rule. That wouldn't have made any sense. So here we are using what we found as in their exhibits, as a reference tool as we move through our deliberation. So I just wanted to speak to that very clearly.
Thank you. And I'll add that at least for my part, I tried to crosswalk. I mean, I think that's why there was such a chaotic mess of binders in front of us on Wednesday. But I at least tried, and commissioners can tell me if I'm wrong, but I at least tried to ensure that section by section, we were cross-referencing not just the applicant's proposals, but also the joint stipulation table that color-coded what language did or didn't change in the applicant's final proposal, as well as crosswalking language from the other parties, including OCC's proposed amendments. We did discuss both IPA&M and NMOGA's proposed alternative language where they did provide proposed alternative language. And I'm happy to note for the record that I am aware that just because alternative language was not proposed does not necessarily mean that parties have agreed to the applicant's proposed language. That language in red and underline is new language that doesn't currently exist, that is being proposed by the applicant. And for lack of blue highlighting or yellow highlighting means that they have not been, they didn't even result in any sort of agreement coming out of the joint stipulation, and that they were just I think applicant and OCD's proposed language. So, and I understand that just because the industry parties didn't propose an alternative doesn't necessarily mean that they concur with the red underlined new text that's being proposed by the applicant. So
Thank you, Mr. Chair. And I would agree with, particularly with the first part of what you said about how we went through the documents in various versions and different parties' positions on Wednesday, really going line by line and looking from one document to the next to make sure that we discuss everything.
and to the extent that if the commissioners feel that we need to discuss the briefs more thoroughly, I'm certainly prepared to do that as well, and to sort of dive more detail or dive into the legal arguments raised in industry's brief in more details as to why perhaps we did or did not find various legal arguments convincing. I'm happy to also lay out more thoughts, my thoughts on those things more thoroughly on the record at some point. And so anyway, I'm ready to do that if we have time. So, and to the extent that we can make time for that. So, but to ensure that we have time to deliberate on all of the remaining questions, my suggestion is that we start by looking at the provisions that we had put a pin in on Wednesday. Is that a good place to start for commissioners?
Sure.
Okay. In that case, and I want to clarify because I can't recall, so commissioners can correct me if I'm wrong. I was not sure whether there was any, I thought there was one position somewhere where we may have adopted the applicant's proposal, but had also agreed to a few additional words from industry parties. Right now, I can't find it in my notes, so I was wondering whether, and we can certainly wait until the tape's out and we can clarify that, but
It says
that
1915-25-9D, second sentence.
19,
1915-25-9D. Second sentence.
second sentence, you said?
Second sentence.
Remind us what that was.
Sure, it's under the general topic of extension and to rebut. So upon request by the operator, the division may use its discretion to grant a one-time extension of a 30-day rebuttal period for good cause.
Yes.
Okay. And we can see that language. I'm guessing we can see that language in green on the MOGA's Exhibit 4. Is that correct?
Number 5.
The MOGA 5, I apologize.
What I read was not verbatim of what Moga has. It was my notes on, but in the one time and we can circle back to that final language. But the question was, that's the one thing that you've changed so far different than the application.
I think it's,
But council, so that one is still, we're still going to discuss that today.
Okay.
Yeah.
Okay. 1915. I'm sorry, 1915-29?
25,
9D.
90.
90, yeah, we're still going to discuss that.
19, 15, 25,
9.
9D. Okay, so I just missed that in my notes here. Okay,
Yeah.
let me write that down so I don't skip it when we get there. 1915, 25, 90. Okay. All right, in that case, the first provision that remains, or the first provision that we put a pin in from last time is 1915-89A.
If I may, I think I may have brought this on us, the proposed addition, based on some questions I asked during the evidentiary portion of the hearing.
Mhm.
And so what Namoga proposed in its closing language was adding verbiage that would say, or the division exercises its discretion and waives its financial assurance requirement because the operator is engaged in plugging operations so that well to be secured will be in the future or for other good cause determined by the division. And, my question back then, the intent of it was to say, is there a world where a well could be bonded or not bonded, but OCD would allow that bond to be released or a well not to be bonded? There was to be action by the operator to clean up that well, and that money could be of use otherwise. I still think that would be a good idea, but in this case, I don't think that suggestion or this language has been substantially developed by any party, and they could potentially, open a door or circumvent the general intent of the rule. For example, currently, we don't know how a party would apply for this waiver, what the waiver would be based on, what factors, what materials would have to be provided to the OCD to make their decision, how long this waiver would be good for, what would happen if the work wasn't completed in a timely manner, what the repercussions of that are, how that would be handled. What happens if P&A isn't done, how many bonds could be waived at once? How would this not be abused? Would there be a hearing, for example? So I just think there's too much uncertainty to adopt this. I wish it would have been developed more by various entities. I had some legs, but I just don't think we have enough on that at this point. So,
Commissioner Bloom, so on this one, we discussed that extensively Wednesday, and I thought that first of all, we all agree that OCD will put up some sort of guidance.
yeah.
So definitely whatever we adapt, they have to put up the guidance to really go with that. So I thought that we discussed this extensively and we're leaning towards just putting a 12 months period right there so that it will be 12 months. For example, let's say if a well is a low producing well, it just started to be a low producing well. Now the operator decides that, okay, I want to probably plug this well. Okay. But OCD is saying, okay, you have to bond this well. Okay. Will this provision not give OCD more like the room to say that, okay, if you are plugging this well now within 12 months, then you are not going to pay the 150,000. So I was thinking that maybe we can modify that language and say that all the division exercises discretion and waives its financial assurance requirement because the operator is engaged in plugging operations for the well to be secured within the next 12 months. And I think we end there.
Commissioners, if I could ask your indulgence to slow down just a second to make sure that we're all looking at the same language, again,
Okay.
the multiple pieces, because now I've got a 1915-89 that has no subsections at all of any kind right here.
Sure, if I can address that. Are you looking at Namoga's edition?
I'm looking at,
version there?
so then there's the Namoga,
So I have the same thing. I think there was an error perhaps in Namoga's submission where there's two sections for 8.9.
okay.
So if you scroll up, I guess the one at the top actually has that language where
Yeah, there's
at the bottom, it just cuts off like it doesn't exist. So,
there's two versions of 8.9A, right?
yeah.
Okay, give me a second. Do you have the page number by any chance? I just want to make sure I'm looking at this.
20.
Oh.
21.
20 out of 1 of. Right there we go.
Here we go. Yes. So it's where, that's right, because there's two different, must have been a typo of some
Some sort
sort,
of typo somewhere. Yeah.
or, yes, okay. Perfect. Now I'm on the same page as everybody else, and now so I apologize. Okay.
Can I
Please.
Okay, so what I was saying is that, I gave an example of situations where it would be good idea for OCD to have this discretion with regards to when to impose the bond. For instance, let's say a well is a low producing well, and an operator is making a decision on it, whether I want to plug that well or more or less bonded 150,000. So the operator decides that, okay, I want to plug this well instead of paying the $150,000. Will this provision not support OCD giving the operator the opportunity to plug that well within 12 months without paying the 150,000?
So, substantively, I understand where Commissioner Mpoma is coming from, and I get that there's, that discretion can be useful. I think the division already has discretion through settlement agreements, through enforcement agreed orders, and the division through its enforcement process and settlement process can exercise discretion. And in fact, if we simply without this language, there already is enforcement discretion by the division. And with Dr. Mpoma, if we call out specifically the 12 months, that actually limits the amount of enforcement discretion, because sometimes we've had operators with far more wells than they can possibly plug in 12 months, right? And so there have been situations where OCD has in settlement agreements agreed to a much longer extension than 12 months as part of a settlement enforcement. I think I would prefer to leave looking at the first green language here, because there's two different green sections, right? Looking at that first green language, I think we can achieve what you're thinking of doing by leaving it out, because again, we already have enforcement discretions. And I would rather do that on a case by case negotiated with an operator, as opposed to, I think, putting the language here, I think invites everybody to ask us to exercise discretion and waive without going through an enforcement and sort of negotiation procedure. And B, we have enforcement discretion throughout throughout all parts of our MAC, and I don't want to open the door to, well, if it's called out as having discretion in this in this one NMAC, how does that work when discretion is not explicitly discussed in the NMAC for other provisions? Does that make any sense?
Yeah, it does. But don't you believe that, so the second line that has been almost redlined in red, the division shall not approve and the operator shall not proceed with any proposed drilling or acquisition of the operating authority under 1915.9.9 NMAC until the operator has finished the required financial assurance. So don't you believe that that provision is more or less limiting OCD with any room?
We've negotiated and allowed deviations as part of a settlement agreement before.
Okay.
So I don't personally have a heartburn about that, but I attorneys for various parties may feel differently.
I'd also point out that the NAMOCA's finding of fact for this cites the expert Commissioner Bloom. So if Commissioner Bloom is not comfortable.
Yeah, he was pushing for this. Yeah. Okay, I'm good too.
I think substantively, we're ending up in the same place because the division still can, through negotiations and settlements, achieve the kind of discretion that I think would be helpful that Commissioner Mpoma rightly points out. And I think by not adopting the language, there is still some base level of discretion, but we avoid the issue of adopting language where there isn't a sufficiently developed record of evidence in the body of evidence in the record. That's my thought on the first green section. Is there, I'll invite thoughts. I have some thoughts on the second green section as well, if commissioners would like to.
You'd like to go ahead, please.
So I think this gets to an issue that repeatedly comes up and is addressed in the briefs about potentially, what industry calls double bonding, right? Or at least some of the industry parties call double bonding, right? So any one section satisfies the operator's plugging financial assurance. That's not currently how it's operated right now. Things do, I looked up Hill Corp, and my understanding is that currently there can be a blanket bond as well as a single well bond. And I think the idea is that the blanket bond can serve as a, because right now the single well bond, even after we adopt this rule, looks at the cost for plugging downhole, right? For plugging the well itself. It doesn't incorporate the costs of surface reclamation. And so oftentimes a blanket bond is still useful as an umbrella insurance policy, so to speak, metaphorically an umbrella insurance policy for related surface equipment salvage and removal, for surface reclamation, for other spills remediation, contamination cleanup. And so at the moment, the practice has not been to interpret that as to interpret these categories as mutually exclusive. And also, if you look at this, and I had some thoughts about this as well, there was a lot of discussions in industry's briefs about how the structure of the famous Rankin Rainbow, because of these commas, makes these categories mutually exclusive. And I'm not so sure that's true, right? Just merely because there's a comma there. If you take the sentence, I drink tea, comma, coffee, comma, and water. The fact that there's a comma between and water doesn't mean that somehow tea and coffee lacks any water and I'm drinking them in the powdered form. So I'm not so sure that the mere comma means that they are mutually exclusive and can't be, or if I drink tea, comma, coffee, comma, milk, doesn't prohibit me from drinking a latte that includes both coffee and milk, right? So I'm not so sure that I buy that I don't buy the argument that the comma is so powerful as to make all of the categories explicitly exclusive or explicitly limiting. And certainly the legislature, if the legislature intended something different, certainly I think the legislature had plenty of opportunities to and could in the future amend that statute to tell us that we're interpreting it incorrectly. But looking at the plain text as written, it simply says that these are shall include, doesn't say shall only include, it says shall include these three things. So so I think the language here, so I think, anyway, that I just want to put that down there, that I'm not so sure that we need to
Mr. Chair, just
go ahead.
back to the beginning of your statement. You said that there are cases where double bonding can and perhaps should occur.
My understanding, and I looked a little bit at a couple of operators' bonds, is that at the moment, there are operators who don't have both single well bonds and blankets. Now, I think it's within the legal authority for us to allow people to fall into multiple bonding categories. Now, that's a different question from whether or not that's a good policy choice. So it would also, so if the commission feels that, that is not a good policy choice and we should make these categories exclusive, I also think the commission has the power to do that.
If you allow me, can I give you an example?
Please.
Let's imagine that this rule is adopted. Company X has 19% of its wells in the situation where if they hit 20, they have to bond everything, right? And some of those wells are in the 19% are already bonded because they were inactive or had problems with their TA status or something like that. Then the company goes over 20%. Does the company have to maintain those existing bonds on those previously bonded wells and then bond everything again? I think that's what could happen here in this sense of double bonding.
Can you point me to this?
Yeah. Okay.
I not that I don't believe you, but help me.
Sure.
Can you help me follow the language here? And like I said, I think we have the legal authority if we wanted to allow companies to fall into multiple categories, but I think that's a different question from whether that is good or bad policy. So as a matter of policy, I'm happy to entertain a debate as to whether or not we should, in fact, make these categories exclusive.
So, all right, let's imagine that an operator has the double bonding would be for the language that Namoga has suggested, which talk about satisfaction of subsection C and G not being covered by both, right? So a company could have a blanket bond, right? $250,000 under C3, right? Same page here.
I see C3, yes.
Okay.
Okay.
Right. So a company could have to have a $250,000 blanket bond.
Mhm.
Then they could have down to D,
Mhm.
low producing wells,
Mhm.
right? So they have 5 low producing wells that they have to bond at $150,000. Okay. Then keep going down to E. Now, operators with 20% or more of wells in an active approved TA or expired TA status, right?
Mhm.
Now imagine that company, they were at 19% for a long time. They go to 25%.
Sure.
Now, under E, they have to bond all their wells,
Got it.
right? So
Mhm.
now they've bonded all their wells, plus they have a $250,000 blanket bond,
Blanket.
plus they have individual bonds for the above low producing wells that got them to 19% or whatever, right?
Mhm.
So now they're double bonded in a couple senses, couple ways, right?
Sure.
One is that what parties intended. 2 is that, a just or functional outcome of this rulemaking. So proper.
Yeah, I don't want to speak for what parties intended, but I think the 200, again, like if we were to allow multiple bonds, I think the justification would be that the 250 would be more like a blanket umbrella insurance policy to cover things that are not included in the calculations for the 150 or 163,000, which is just downhole plugging. It doesn't include things like hauling away the pump jack or surface equipment or reclaiming the surface, right? So we would have another 250,000 as a blanket for addressing additional surface. But I also hear the point about how this would make the rule even more financially burdensome for operators, and I want to be sensitive to that as well. So if the commission feels that there's potentially a compromise in here where we could limit the multiplicity of the or limit the limit the scope of this rule by only allowing one section at a time. I'm open to that as a matter of policy. The next question I would have is we just need to double check, dot our i's and cross our t's that would that there's substantial evidence and and let's just take a quick look that this thing would still hang together if we were to make that change.
I had that concern as well, Mr. Chair.
So would there be a path forward on that?
Well, first, I mean, it sounds like the commissioners, at least my fellow 2 commissioners, have an interest in adopting the green language in 1915-89, the last green section to, right? Is there interest, number 1? So there is interest. I see nodding. So then the second question is, would there be substantial evidence in the record to support that? And how does that maybe reverberate through the rest of the rule?
I just searched the Again, the applicant's closing, it does not mention double bonding. Looking at the MOGA's closing.
It's discussed quite extensively. IPNN and those both it discussed it extensively.
There was another double bonding that MOGA and I believe IPNM discussed as well.
Yep.
Which was, potential overlap with the land offices bonding, but again, those are trains on different tracks. I think that is equivalent or tantamount to a sense of double bonding that could be created here.
Well, and I don't know how to address double bonding related to the state land office, because as far as I understand, there might be an active rulemaking over there, but it hasn't been decided one way or the other. So
And this sounds like something that the hearing officer might need a few minutes just to get everything organized. So maybe we want to pass over this one for right now.
let's note that there is at least there's commissioners' interest in exploring that, and then we can come back and maybe get some advice.
And I, as I looked through this, I thought Namoga's language would not create other issues, solely address that possibility of double bonding. But I hope I'm right and wanted to check that with you all. So.
I will note that I see interest in that, or at least interest in exploring that further from at least two of the two commissioners. So I have two fellow commissioners. So it's definitely worth exploring further with our with commission counsel and commission our hearing officer. Is there any, I don't recall, I have an asterisk on my document here, but is there any debate on in the same section, 1915-8-9, is there any debate with the red underlined language, whether or not highlighted in blue?
Mr. Chair, so you've clarified that even though with that provision, OCD still do have the room to work with operators to be able to more or less work through this. So I do not have any concern about that.
For some reason, I have a dot in here. I don't know if it's just a stray mark, but I had a dot next to the blue language. This subsection A applies to subsection B through H of this section. That didn't seem like that was controversial for anybody, so I'm not sure why I have a dot there, but just thought I'd ask and see if I didn't have any concerns, and it seems like it's one of the language that had relatively broad party support, so just want to confirm that we didn't have any further deliberations on that.
And then the more guys put in a comment.
Yeah, I'm just reading through this, one last time, making sure that that sort of language work.
Can we now go through the other ones before we come back to that? Because I mean, that impacts everything beneath that, right?
Right. Okay. So in that case, we're on to 1915-89D. 4, I believe, which shows up in, not in the, if I understand correctly, not in the applicant's final, but in NEMOGA proposals.
I think we'll deal with 3 first.
D3?
Yeah.
Okay.
We're at
1915-89 D3.
D3.
3.
Three. So, Mr. Chair, on this one, if you read through NEMOGA's closing and briefing, it sounds to me that the parties only more or less discussed and agreed mostly on the well stream, the midstream takeaway capacity. But during the hearing, we went back and forth a lot on multiple situations where operator might not be able to satisfy this provision. So I've thought about this, but I'm not sure how we can connect what NEMOGA is proposing to what they've agreed to. NEMOGA tried to summarize all that has been agreed to under the 3 right in their point A. That will be a physical impediment limiting the well's midstream takeaway capacity. And the demonstration shall also include the notification from the midstream operator required pursuant to 19.15.
Sorry, just to clarify, Dr. Poma, so that's in the part of the joint stipulation, correct? In blue, yeah.
Exactly, right there.
So those parties, yeah.
Those parties agree.
The parties have agreed to a variance.
Raise this variance.
They're fighting over what the criteria should be. They're also fighting over what the process should be.
So on that, you'll see that the joint stipulation all still talks about mostly the midstream. So if you look at what NEMOGA is proposing, they are summarizing the joint stipulation at 3 right at their 3A. And moving on to add other categories that we discussed. Yeah, exactly.
And we ruled those out, yes.
Exactly. You said we ruled those out?
I thought we did.
I thought.
We hadn't, we're still going? Okay.
Yeah, I thought we said we would have to revisit this one more time. And even yet on Wednesday, you thought that
Okay, I thought we were revisiting 4 underneath, which is the variance procedure, but.
That's what I had as well, just that we agreed to 3, but that's fine. The deliberations are ongoing, so to the extent that there's
Things permanently shelved, so
nothing's permanently shelved.
gavels this thing down.
So if we would like to reconsider D3, now's the
Okay.
time, please.
yeah, so yeah, I thought that we're still talking about D3. So but again, I just want the commission to reconsider this.
Sure.
Because if you look at the joint stipulation, it is mostly on the midstream.
Mm-hmm.
But there are other factors too that NEMOGA is laying out here, and we discussed that extensively during the hearing.
Okay.
So we can probably go through it and then rule some of them out, or at least discuss that.
Please, please.
So the way I look at it, NEMOGA tried to summarize the joint stipulation right at 3A,
Mm-hmm.
and then moved on to talk about the B. That will be a compression or facility limitation. And also C, an operational safety requirement. D, a regulatory safety directive or operational hold. E, a proximity operation or interference, including nearby fracturing, stimulation, drilling operations, impacting safe or prudent pressure practice, which is very important too. And then a force majeure event, including an act of God. Now, the G is the one that I do not know much about, that probably Commissioner Bloom can speak to. And then the H, financial capability based on well economics, operational plans or plans to improve well performance or any other relevant information. So that one too, I'm not so sure about that. But the last one, no current market, or the only market will require selling at a loss, which constitutes waste. So that one, the I will be closer to what happened during the COVID. So I believe that some of these points make sense, but if you read through the joint stipulation, I'm not sure it covered all of these potential issues.
Yes, I think if I recall our conversation yesterday, Commissioner Bloom and I think are concerned about how broadly that people might try to interpret some of these provisions. Because requires selling at a loss, that comes real close to, well, if requiring selling at a loss makes me concerned about the financial viability of the company, which does increase risks of abandonment and orphaning to the state, right? And also require selling at a loss. Well, so if I'm a terrible business person and I just don't control my costs and run them, that seems to me like we would have to do a lot of economic inquiry that I'm not so sure that to certain industry operators, be careful what you wish for, right? Do you really want to open up the books and have us try to figure out whether or not your profitability looks like? And also to the extent of COVID, I think COVID probably fits better under force majeure than mere economic loss anyway. But even force majeure, I mean, if there was a force majeure where the governor announced a state of the emergency, I think we'd be looking at much broader, suspensions of other sections anyway. The compression facility limitations, compressor failures. The variance process is a pretty convoluted process, and it's time-consuming process, right? If you've got an equipment failure that lasts as long as it takes to get a variance, I'd be very concerned that that equipment isn't being repaired in a timely fashion. So I get some of these, but I certainly would encourage the commissioners to at least narrow some of this language. If we were to consider adopting some of these
Yeah, so I will,
reasons for variance.
so I will encourage that we read through 3 and then compare to what you guys proposing here.
Sure.
And see which ones really cover those, and then we just rule them out.
Sure.
If the commission would like to do that.
Let's do.
Yeah.
It's important to me that every commissioner gets to say their piece, and so please go ahead.
Yeah. So if you read through that, and I will read through sections of those. It says, upon a demonstration satisfactory to the division that there is a physical impediment limiting the well's midstream takeaway capacity. So right there, it is all centered on midstream takeaway capacity.
Mhm.
Demonstrations include a certification from the operator detailing the nature of the physical impediment, explaining why the physical impediment is outside the control of the operator, detailing the alternatives that were or are being explored to address the lack of the takeaway capacity, and an estimated date when the lack of the takeaway capacity will be corrected. So if you look at all of that, is all on the midstream side, it's all on the takeaway side. But what about some of the items that they proposed?
Okay,
So-
let's take the other proposed.
Yeah, one after the other. And I was saying that NIMOGA 3A more or less summarizes all that has been agreed on here. And that would be the physical impediment limiting the well's midstream takeaway capacity. So that one more or less satisfies or more or less summarizes all that has been agreed on for 3A. For the 3B, I would say the B more or less makes sense to me, but I don't know if we want to discuss that.
Let's discuss it. We can
Yeah.
discuss whatever
Okay.
you want to. This is
So let me just ask you, if A says that there's a physical impediment limiting the well's midstream takeaway capacity, B to me is just
is
more
exactly that,
examples of midstream capacity. So I think it's redundant. It doesn't need to be that.
Okay.
right? I mean, because compression facility limitations, that's midstream, isn't it?
Yes,
Compressor failure. I mean, that, right?
I agree to that.
Equipment scarcity. Now that's a real squishy. Supply chains are real. I don't want to downplay the challenges for operators in supply chain constraints, but that's a real broad door. If, it's
Could that include,
compressors are,
we can't get
Yeah.
the pipe to the site because when it rights away or something? Well, that's,
or just like,
that's a scarcity of the equipment going in.
or just the turbines are currently back ordered. I mean, it's that alone, I think, turbines are in fact currently back ordered, right? Turbines are very popular right now. Is that a scarcity that would make, I mean, so I think that language is too broad for my comfort. And plus, equipment scarcity presumably means midstream equipment scarcity. I can't imagine that, a refinery having some equipment scarcity shouldn't, I mean, I think that would be fairly outlandish if, lack of trucks at a refinery would somehow constitute equipment scarcity that would impact well bonding, right? So I think equipment scarcity, the way that's written here, to make sense, we'd have to interpret it as midstream equipment scarcity anyway, and so therefore would still be captured in midstream.
Okay.
Maintenance or processing plant downtime or inlet restrictions, that still seems like midstream.
Still.
So I think B is, not that I disagree with B necessarily, but it's covered.
It's covered, yeah.
Okay, C. Again, curtailment for, this is what, C is one of those ones where an operational safety, curtailment for the protection of life, health. So we're talking generally speaking about emergency situations. But this section is around a variance request to bonding. A variance request is a long process. So if you've got some sort of threat to human health and the environment that lasts long enough for a variance process, something's very wrong.
So in that sense, that might not necessarily take a longer period to be resolved.
I'm sorry? It shouldn't. It doesn't make sense to me that there would be some sort of emergency situation that lasts long enough for people to go through a whole variance process.
Okay.
And I'm a little bit more open to regulatory safety directive. I'm not sure what operational hold might mean.
Does this get back to what you were just saying about emergency type situations where, if the regulatory safety directive is that your pipeline corroded and shouldn't be permitted for use right now or should be suspended from use. I'm not sure that should mean that low producing well gets a variance. I don't know.
So let's say if there's a pipeline connecting these wells to the storage tank, for instance, right? And then, like you said, there's a problem with the pipeline. Now, these wells cannot produce. But let's say the regulator says you have to fix this before you can more or less bring all these wells back on stream. Would that not be more like a?
I think it would depend on whether that safety directive was also directed at a third-party midstream facility or, on lease. Could it be on lease? Could it be in a unit? So under the control of the same operator, right?
Mm-hmm.
So some of those, you might get a variance. If it's not your fault, maybe you get the variance, but otherwise, but I guess again, this, to me, I almost feel like as we're talking about it, we're coming back to midstream takeaway capacity issue.
Because if it's not midstream, right, first of all, I don't know that we should consider like all the, shipping, or refining issues because that's so far removed from the well plugging issues that we're trying to address in this rule, right? Number one. So we're talking about either midstream or at the well itself. If it's midstream, it's covered by the language that's negotiated around midstream. If you have a safety upset and somehow your well is too dangerous to be operating because it's actively on fire or something like that, I'm not sure that that's a good reason for you to get a variance from bonding, because if you are unable to operate your well in a safe manner and comply with safety regulations, I feel like that actually means that this is probably an operator that I want more, that I want to keep an extra eye on and make sure that we have bonding for. I certainly don't want to create a perverse incentive where if I can create a health hazard, maybe we can avoid bonding. That doesn't seem to make sense.
No, so these wells are actually bonded, but to raise the seal to the 150,000. So these wells are actually bonded, but they more or less become a low producing well,
Well, sure,
which will increase your bond,
I understand.
right? So it's not like they are not bonded. They're actually bonded, but just that room.
You can stay at the lower,
Exactly.
you can stay at the lower bonded rate if you make sure that there's a health hazard and an environmental hazard coming through your well. That doesn't make sense to me.
Emergency.
Please light a few of them on fire so you don't have to bond at a higher level. That doesn't make sense.
But do you think operators will do that?
I hope not.
But Mr. Chair, so on the regulatory safety directive, what could be an example that might not necessarily fall under the midstream?
That's why I was trying to think of like, I mean, unless your actual well is is on problematic, right? So that, and look, safety directive, I'm a little bit more open to, but operational hold is too broad for me, for sure.
Exactly. That's a loophole.
So let me just provide some advice. You have options, okay? And you can continue this discussion. But the backbone is, where is this in the record? And so the finding that Emoga has is number 70, and they have, the expert is Commissioner Bloom questioning Mr. Arthur, and that's about midstream and takeaway shutdown. And then Commissioner Bloom questioning Mr. McGowan about midstream shutdowns and force majeures. There's nothing further about the Emoga's findings supporting their 6 or 7 things that they've listed here.
If you look through the transcript, these are, if I remember, because I mean, this was one of the items that we talked about. So we probably would have to cross-reference the transcript because I'm really sure that we discussed some of these issues. I'm really sure that we discussed some of these issues, not just only the midstream takeaways, as I recollect. So this will be something that I will have interest in to really discuss more extensively.
We can certainly go through policy-wise what Commissioner Mpoma believes first, and then, but I think before we choose what to adopt, we'll have to make sure that we've got a record to support whatever we do want to adopt at the end.
On that issue, I would just actually agree with Mr. Chandler. All I'm finding on the lack of takeaway capacity and other impediments midstream is the conversation between Commissioner Bloom and Mr. Arthur. That's what I'm finding.
So I realize the first 2 things I've suggested to table them again, and that's going to be very frustrating as a human to another human, but it may be appropriate during a break that we can quickly go onto the computer. So that's my advice. If something doesn't jump out after like 15 minutes of a discussion, maybe we should put another pin in it and just make sure that everything is, we've given you the information you need to make the best decision.
Sure.
You know, Mr. Chair, the only thing that I remember that I really want us to really take a closer look is the item E. You know, so a proximity operation or interference, including nearby fracturing stimulation, drilling operations impacting safe and prudent pressure practice.
Okay.
And this one is the one that really stands out to me, that it doesn't fall under the midstream, but this one is something that can occur.
That's fair. I can see how that's certainly a reasonable position. And while we wait for an opportunity to go back and see what the record might reflect on E, I'm happy to quickly run through F, G, H, and I just to make sure that we, as a matter of policy, what you guys' thoughts are. So again, I think if there's an emergency or an act of God, the governor's emergency declaration is going to be a far more effective tool for addressing that kind of emergency situation than trying to apply it for a variance and go through a whole rigmarole for a variance, right?
Yeah.
So I think,
Yeah, and on that, and just I think to go back to what Mr. Chandler, the hearing officer, said, as I'm looking through this, I just went through Namoga's closing, looking at the word variance, and there's not really testimony on the variance. There's just some statements in there saying that the parties agreed to variance language, which was under A. You know, I just searched under fracturing and was not testimony on that. I don't think I recall any testimony, you know, of what the effects of this could be if there was a temporary shutdown because of fracturing. And, you know, I mean, a lot of times, you know, well completions, they could be on location for a while, but again, it gets kind of far out there. You know, I think force majeure events are something that can be used in a rule to drive a truck through, right? So there's some issues there, but generally most of these things have not been discussed
or vetted,
right,
yes.
vetted, so.
Yeah. But even if there was, I'm just saying, I don't think as a matter of policy, I think the force majeure clause, a variance is not the way to go about addressing some real earthquake. Right? If there truly was some sort of disaster, natural disaster, giant, I don't know, forest fire, earthquake, some truly COVID, a governor's emergency declaration, there's other mechanisms that's going to be more effective for that anyway. And then same with, I mean, H to me is too broad. H and I are just far too broad and would sort of swallow the rule, so to speak. So I'm not so fond of H and I as a matter of policy. G, that seems to read to me, and you can correct me if I'm wrong, Commissioner Bloom, but seems like G is meant for somebody to use a well as to hold on to a lease, like a federal lease or something along those lines, right? Is that how you read that? And I'm not sure that that's a sufficiently good reason.
And I'm not sure that an exception to our rule should be whatever happens to appear in, say, a BLM lease.
Lease, yeah.
Or it could be in one of the 20-some leases that the land office has, the legislature has created since the time of statehood. So.
Okay. So really, I think the open policy question or the part where I think we can that this commission has interest in is E, right? This idea around fracturing, stimulation, and drilling. So then maybe we can then ask commission counsel and commission hearing officers to see whether or not there's, you know, whether or not the commission wants to, if the commission were to want to adopt E, whether or not there's any evidence that would allow us to do so.
Right. I believe we discussed H. Which to me sounded like a way to get around almost the entirety of.
Yeah, H is
of that section. Yeah.
H would swallow the rule. So I'm sorry. Yeah.
We can't afford we need a variance to our bond because we can't afford the bond. And yeah,
It would defeat it would swallow the rule. So
the financial capability.
right. But I concur with Dr. Mpoma's point around, you know, E deserves some thought as a matter of policy. Now, whether or not we have the mechanics of and sufficient evidence in the record to include it at this time is a different question, but I thought that was a useful discussion. So thank you.
Thank you.
The next would be 4 below that. The way we would bring that variance process into the rule. Is that right?
Yes. So my thoughts on here is that 30 days, right now it's silent and we're going to end up with a dispute as to what happens when the 30 days expires and the division somehow was not able to come to decision. I would be fine with this if it's a 30 days to approve. Otherwise, it's an auto denial because that, you know, but I think I would have heartburn if it's an auto approval of a variance.
Okay. But don't you believe that probably within the 30 days, the staffs probably would not have had enough time to really make a decision on it?
So Yeah, so I'm fine with the, if the staff acknowledges and so I don't, let me, what's the way I want to phrase this? I don't mind if the process takes longer than 30 days to play out and if there is an exchange of information and ongoing consideration. What I didn't want is for OCD, for lack of capacity, to have not even had a chance to review it in 30 days and a bunch of variances get auto approved.
But what about auto muted or like it's approved?
So I think the division, if the division says we acknowledge this variance, we think it may have merit, we need more time, then I think that calendar will keep rolling. But it's sort of like our, the way I would frame it is like when we get a motion for rehearing at the commission, right? If we take no action, it's automatically denied. However, if we take action to take it up, it doesn't mean we have to do the rehearing within 10 days, just that we decide whether or not we are going to hear it in those first 10 days. Does that make sense?
Yeah, it does.
So on 4, would you, Namoga's suggested number 4, at the end of the first sentence, would you be comfortable with adding something to the effect of no reply shall be considered denial? End of the first sentence.
Yes, something along those lines is the way that I would, yeah, I think I'll have to think a little bit about language and maybe commission counsel can advise.
We have that elsewhere.
Yeah, and we'll probably pair it as closely as possible, other parts of the
But
NMAC.
that would take it to, a hearing. If the division denies the operator's variance, the operator shall have 30 days in which to file a request.
For hearing, correct. So the language in the rehearing provision, thank you so much, Commission Counsel, says the commission shall grant or refuse the application in whole or in part within 10 business days after the party files it, comma, and the commission's failure to act on the application within such period shall be deemed a refusal. Right? So I would my suggestion is to parrot that similar language in here that says, it shall be 30 days. The division's failure to act on the application within such period shall be deemed a refusal. Or a denial. If the division denies the operator's variance by silence or otherwise, the operator shall have 30 more days then to file a request for hearing.
That works for me.
That works for me. Yeah.
That is, if you can repeat it.
As long as I have this in front of me, I can. Do I need to write this down or have you got it?
I believe we're gonna have to put a pin in this and come back and actually get the exact language for the record, but it sounds like in principle you have some language. So during the break, we can just write it out.
Be a busy break.
I thought we were gonna be done before 12. Yeah.
But thank you. I think this language works for me because it tracks the other provisions of the NMAC, right? And even if the division takes no action, it simply goes to a hearing. So it's not I just didn't want it to be automatically deemed approved because then we could potentially have problems.
Okay.
Okay.
So there is a new 5. That is not in the stipulated joint stipulation.
That's because that
So now
4
becomes-
pushes it down, right?
5, yeah, okay.
That 5 is an operator may furnish all necessary plug-in financial assurance in the form of a single instrument. The deletion of one well, operator may furnish all necessary one well.
Yeah, it's the same language and yeah, it's
And I think as we were going through on Wednesday, we were good with that deletion of one well as what we saw. So
and it's just they may furnish. They don't have to, but they may. So okay. Next on my list, and again, please do stop me if I skip anything, but the next on my list is 1915-89F.
Yes. So, Mr. Chair, on this one, Commissioner Bloom, if you look at the original language, the one that has been crossed out, see that it says covered by subsection A of 15.9, 19.15.8.9 MR.
I apologize. Give me just 1 second to flip to it so I can track as you're reviewing it. I have 9F here, but now I'm numbering on this one is off again. Okay.
Got it?
They're numbered different, or they're alphabetized differently, I think, maybe. And let me see, give me just my second.
What is the title of the section in the first couple of words of it?
Inactive
Active wells?
and wells and approved and expired temporary abandoned status, right? That's the one we're looking at?
Yes.
Okay. So it's D in the MOGA version, right?
That's correct.
Okay.
So, Mr. Chair, here, the issue was whether to agree Nimoga's revision of striking out the approved, and then also there is expired or approved temporarily abandoned status for more than 2 years. So the 2 years was the one that we're discussing extensively on. Now, I think Commissioner Bloom wanted us to look at the original language. So that is the one that has been striked out. And it says covered by subsection A of 19.15.8.9 MMAC that has been in temporary abandoned status for more than 2 years. So there, Nimoga wants to bring it back to have that room so that after the 2 years, then any approved TA well could be bonded at 50,000. So
I think you're gonna have to explain that because this is very complicated. So
okay.
say that again.
Okay, yeah, so on this provision, I more or less agreed with Nimoga that an approved TA well less than 2 years should not, there has to be a distinction between expired TA and an approved TA for 2 years
Okay.
before that well could be bonded at the 150,000. The way it is written in the original language is saying that inactive wells and wells in approved and expired temporary abandoned status will all be bonded at 150,000.
Yes, yes, Namoga's version brings back the language for more than 2 years as it applies to temporary abandoned status.
Approved temporary abandoned status. Yeah. So I agree with their statement, because definitely there has to be a distinction between expired then approved. So approved, there has to be some motivation for companies to really make sure that their TA wells more or less has been approved. With this provision, then probably there will be no motivation.
I don't follow.
So that what is happening here is that in the original language,
Say that again.
the original language,
Yeah.
that is the one that has been striked out. Companies do have 2 years to be 2 years for their wells in TA status to be bonded as a TA well. And in this case, it's going to be the $150,000. Now, Nimoga wants to bring back the 2 years. So let's say if the well is in TA, approved TA for 2 years, they don't get bonded at 150,000 until after the 2 years. Then they will be bonded at 150,000.
Are you saying there's a grace period in the current status quo?
Yeah, if you read through the one that has been striked out. Yes, there is a covered by subsection A of 19.15.8.9 MAC that has been in temporarily abandoned status for more than 2 years. So that is what they are trying to bring it back for the approved TAs.
Mr. Chair, is that in fact how the division currently interprets that section? for there to be a grace period?
It appears that that is, I don't personally handle the bonding very much, so, but my understanding is that that is in fact how it's written, temporarily abandoned status for 2 years. But I guess perhaps we can also ask what findings of fact that Namoga would point to on that.
If I have,
And if I interpret the joint stipulation table correctly, this is actually a provision that's supported by OCC. Not Namoga, not IPNM, but OCC. And while we do a little bit of research, actually, may I just in a recess so that I at least can use the restroom?
Right behind you.
Okay, in that case, without objection, if we could briefly recess for, let's just say, hang on, give me a second. How about 10:30?
Yeah.
Let's return at 10:30. Thank you. All right, returning from a brief recess. Are we back on? Is the audio live?
Yes.
Great. All right, I apologize for the interruption. Let me just make sure I'm back to where I'm at here, which is is it D4? Oh, no, we are in S, yeah, we're in F. That's right.
So I point the commission to the MOGA's closing arguments, page 11, 77.
Which one was that again? Sorry, guys.
So it's the MOGA's closing arguments, 11 of 77. On the fourth tab. If you're in your book, but and I'm going to read it and then I'll turn it back over to. Sure.
I'm sorry, 1 second. Which paragraph again? Or page 1177 page?
Yes.
Thank you.
It's,
Looking at F.
yeah.
That's what I was looking for. Yeah, thank you.
So there's a couple of things going on that's worth building the record a little bit more, then I'll turn it back to you. But this organization is arguing is that section 7214A, you know, that is the main rainbow statute. They argue that that statute has a requirement that things in more than 2 years. So they think it's actually a statutory requirement. I think the applicants do not read that language, make it a statutory requirement of a 2-year grace period. And they've made that argument in their briefs. But going further, it sounds like Commissioner Poma had a policy discussion about the 2 years. So at hearing, Commissioner Poma indicated his support for keeping the current scope of the TA-specific FA regulations, which at present allows wells and TA status for up to 2 years to remain eligible for the active well blanket bond option. Goes on to read about Commissioner Poma concluded that by noting he thought the risk of not allowing the operators to use their active well blanket bond to cover active wells and approve TA status for short periods of time, years or less, for example, or being transitioned, be an issue about the oil recovery projects. And they cite to a discussion in the transcript between you, Commissioner Poma, and Purvis, which I think was one of the applicants' experts. So the proposed rule strikes out the 2 years in the rule. Sounds like NMOGA wants to keep that in there. It sounds like you're ready to have a policy discussion about whether that 2 year, what I called as a grace period, which is inaccurate. I should be much more precise and get you to get on the record what that 2 year period is. But that seems to be a dispute whether the 2 years should stay in or be taken out. Okay.
Yes.
And again, I shouldn't have called it a grace period because there's nowhere that anyone used that word. So that should be struck, from the record. Why don't you better explain how you understand this, what happens in the 2 year period and what people do as you understand it as a policy. And then maybe we can turn to the chair for his reflection of what the division understands it as the policy. But that's my attempt to try to refocus the discussion.
Yeah, and thanks for pointing us to this. I was really trying to look for this one. So thank you. So based on what you just described here, I believe that, listen, before you can transition from primary recovery to, let's say, secondary recovery, water flood, you need a series of, let's say, planning. Now, the way it works is that wells that are not able to produce enough, you try to stop producing. And then, let's say, wells that are producing more water, for instance, you tend to more or less stop producing that because the water catch is so high. And those are the wells that you tend to become water injection wells. So definitely that 2 years period will give them the chance to utilize such a well for water flood. Other than funding it straight away to, let's say, 150,000, without giving the operator the chance to really prove the worth of that particular well. And I think if you read through the 17-2-14, that was something that we discussed as well in there. And I read the Oil Conservation Division, and I don't know what is with May has been cancelled, so I don't know. Shall require a one well financial assurance on any well that has been held in temporary abandoned status for more than 2 years. So this one is in the statute. And Nimoga wants to do that. And I do support that because of what I've laid out.
So, did you want to?
I just had a question, Dr. Ampoma. So, Dr. Ampoma, is it your understanding that there's I'm looking at 19, 15, 25, 13. Part 25 is one of the rule we're looking at, right? And I'm looking at the language, the new 13 for approved temporary abandonment. So if I was looking at the MOGA's alternative language document, that would be page 33. Okay. So it says A, it's under approved temporary abandonment. A, division may place a well in approved temporary abandonment for a period of up to 5 years upon a demonstration from the operator that the well will be used for beneficial use within the approved period of abandonment. Then you go down to C with the MOGA document, and then there could be a period, 2 more years. Let's see, extension, C extension 1. Prior to the expiration of a renewal of an approved temporary abandonment, the operator shall return the well to beneficial use, et cetera, or apply for an extension. Maybe it's, you go down to MOGA's 5. If a well can meet the beneficial use demonstration mechanical integrity requirements set forth and applicable to subsection C for the 5-year extension of temporary abandonment status, the operator may apply 5-year extensions of 2-year after the initial 5-year. I mean, I guess we've already dealt with that or not, but I thought it was 5 years plus 2 years plus 2 years. So before, where I was going with that is before that, the 2-year, also the 5-year period for temporary abandoned wells.
So I'm not going to be able to articulate this very well because unfortunately this is not something I deal with in the division on a daily basis. But my understanding, I'll try to make this as minimally painful as possible. When the statute talks about A, the division, as I understand it, has interpreted that to include not just approved TA or expired TA, but include inactivity, as in like temporary abandonment broadly. So under our current requirements, you have 15 months that you're allowed to be inactive before you even have to start going through the process of applying for TA or plugging, right? So there would be functionally a more than 1 year period where a well could be, in layman's terms, temporarily abandoned or at least inactive, non-producing, before then it applies for temporarily abandoned status, right? And so functionally it would be more than 2 years because there's already a 15-month period before we can require people to into TA status. So there's already an inactivity period. So just because the well stops producing today doesn't mean it has to be TA'd this very day. There is a existing period, the way that it is, the way that we operate now, there is already a more than 1 year period that an operator is allowed to be inactive before they have to determine what they want to do with it. So Then you get into TA. Then you have to apply for TA after 15 months, or either plug or then get into TA status. And it's not great that the sort of approved TA versus TA in the statute versus approved TA in the rules refer to slightly different things. And that may not be the best way that to have done it in the past, but that seems to be the practice as I understand it today.
Mr. Chair, then how do you defend, or more or less, the one that we just read in the statute, given the way I look at it is that, let's say a well that is producing, and then the operator decides that they want to put it in TA from the onset, not necessarily a well that has already been approved. So we're talking about an active well that is just tending to become an inactive well. So what you just described, I mean, how does that translate to what is in the statute that, let's say wells has to be in 2 years, at least 2 years before they are bonded as an actual TA well?
So you're talking about the provision of the statute that says the OCD shall require a one well financial assurance on any well that has been held in a temporary abandoned status for more than 2 months, right?
Yes.
That's what I was trying to discuss. I agree with you that it's confusing and may not be the best reading of the statute, but historically, the reading of the statute is that temporarily abandoned status in the statute is different than approved temporary abandoned status in the regulation. Whether or not that's a good reading of the statute or not, I'm not here to debate. I'm just, as a factual matter, the division, my understanding, and I wish we had the actual subject matter experts here to describe this better, but my understanding is that the division has read the broader temporary abandoned statuses of all kind to include inactive wells in the, so as soon as somebody says, I'm no longer producing it, it's for the purposes of the statute, temporarily abandoned, but it is not approved temporary abandoned status for the purposes of the regulation.
So, and I'll go further that the applicants complete closing arguments for first half, page 6. You can hear their voice of what their argument is. So that's the applicant's closing brief, page 6, the very bottom. Letter 2, probably something to find. The very first tab in the binder. It's binder.
Applicants closing, page 6.
Yes.
Just getting the getting the table of contents there.
So not, go on until it's numbered and not Roman numerals.
Okay.
And it should show up, there's a heading at the very, very, very bottom, page 6.
Maybe it's 13 out of 156 on the PDF.
Yeah, there was some more on page 30 that I was just about to call our attention to on the same matter, so.
Yeah, so even reading that, and then if you go to the applicant's post-hearing brief, I think their whole understanding is that these wells do have a high risk of becoming orphaned. And as an engineer, I'm like, how does a well that is producing that is producing now and just transition to TA status become a high risk well within the first 2 years? I don't understand.
But that's what we're trying to, that's what I'm trying to explain is that that's not the way it's currently interpreted. Now as a matter of law, it's a whole different discussion as to whether that's a good interpretation or bad interpretation of the way the statute is written. But the way it's interpreted, there's already a 15-month period where you're neither approved nor expired, or you're just TA'd without further explanation. And then there's approved TA status for 2 years on top of that. So there's already a 15-month built in where you're simply in uncleared TAs, amorphous TA status versus an approved TA status.
But Mr. Chair, with this rule that we are enacting now, we'll take that out. Because right now, as long as that well becomes low producing well. So if you look at what we are doing now, every well has to be bonded at the right bond. That is what.
Once they are approved TA, not merely inactive TA. Does that make sense?
So the way I look at it is that all wells, every year, companies would have to submit their wells, their status to OCD. So let's say if there is a low well, a low producing well. Now.
And they can shut it off completely.
Exactly. So operator can decide.
Yes.
That well to TA.
No.
Or let's say, no, to move that to inactive. Let me put it that way.
Yes.
Right?
Okay.
And then they can try to figure out whether to bring this well back on.
Correct.
To produce more.
Correct.
Right? But from what we are saying, once it is flagged as a low producing well, they have to be bonded at the right amount, right? So either you bond at 150.
For low producing. Yes.
Exactly. So I do see that as a transition. But let me ask,
Okay.
do we have any problem if we are to leave that 2 years in there? What would be the issues with leaving that 2 years?
It would extend the period, because I think functionally, and we can certainly revisit in guidance if I'm describing any of this process incorrectly. But my understanding is it wouldn't just be functionally 2 years after the taps turn off. It would be 2 years plus 15 months. So it would be a period pushing 4 years.
And the 15 years is in the 15 months.
Is in a different, is in the,
To the 13?
in the regs, but I don't.
13. Yeah, we go to 13.
Yeah.
Okay. Yeah, if you feel comfortable that, let's say the 13 will take care of my issues, then I do not have a problem. So probably we can go to 13 and come back to this one to make sure that we are all on the same page.
I don't necessarily, well, I just want to flag for you that that adopting the 2 year may functionally push it close to 3.5. As opposed to 2. Now, whether 3.5 versus 2, where the policy lands on that, reasonable minds may very well disagree. But I'm just flagging that the way that it's currently set up, it would be more than two. The 2 years would be in addition to the 15 months of inactivity that we have considered amorphously T-dayed for the purposes of the statute, but not approved TA for the purposes of the reg. That's all.
So I interject when you're ready. Okay.
Please.
So if we look on page 73 of the applicant's closing, this would be page 60, page 66, but it's page 70, 66 at the bottom. Finding of fact number 248.
Give me just a second.
We need to, right?
For the. So at the bottom, it says 66 or at the top? It says 66.
This is on the bottom, 66.
Okay.
Yeah, bottom 66.
So finding of fact 248.
Okay.
This is what I've been putting together, right? That so it says, quote, generally a well that is up for TA renewal has been inactive for 6 years, right? So it's the 13 months that you're talking about, Mr. Chair, plus the initial 5-year period, right? And then there would be a 2-year renewal. So that at that point, you're, at 8 years. Okay. And the likelihood that that well will be put back into productive use after 8 years becomes increasingly rare. So you go down to finding of fact number 249. The vast majority of reactivations of inactive wells, over 90%, occur within 3.5 years. So, this bonding for that first 2-year period would only be bonding less than 10% of the wells that ever went to TA status, right?
The vast majority of reactors.
That's why I would support the applicant's language here.
So do you believe that, and Mr. Chair, so you are a lawyer too. So Nemoga is saying that we do not have the authority to take out that 2 years because it's in the statute, right?
That's correct.
So how do we defend that, knowing for sure that, I mean, it's in the statute and it's right here too, okay? So how do we defend that using what has been proposed in 25.13?
Yeah.
Please.
So going back to Mr. Rankin's rainbow, the last sentence of 70-2-14 is well conservation division shall require a one well financial assurance on any well that has been held in temporarily abandoned status for more than 2 years. Right? What the applicants are doing is creating a new financial assurance that covers that first 2 year period.
Yeah, to 150,000.
150,000.
250,000. And the industry is saying, no, give me that breathing room to make decisions as to what I really want to do with this well.
But remember that most companies, and I think this is what 240, the finding of fact 249 and the applicant's proposed closing arguments goes to is the vast majority of reactivations of inactive wells, over 90%, occur within 3.5 years. So only less than 10% of wells would even hit that first 2 year period and have to be bonded.
So the vast majority of reactivations of inactive wells, over 90%, occur within the 3.5, so the early stages. So then why are you bonding them at 150,000? Don't you believe that we're going to preempt, let's say, immediate plugging of these wells?
No, I think we would either see them return to production or potentially bonded or potentially P&A'd.
So I'll be comfortable, like, so the chair is saying that before even they get to this situation, they've already been inactive for 15 months.
Or they're allowed, yes. But sometimes if people are out of compliance for more, just because we don't catch it in time.
Is that captured in the rule?
That's my understanding and the reason why this hasn't been challenged previously, because that rule has been in there or this has been the way that the division has been operating for a while. So my understanding is that there is, that's the way it works. But I certainly acknowledge that that there is room for attorneys to argue.
Yeah, I do feel that probably Nimoga might use the fact that they're saying we do not have the authority.
I I understand that Nimoga is likely to feel, I mean, Nimoga explicitly states that.
Yeah, exactly.
Yes.
Exactly. So I'm just, unless, let's say there's a 15 months somewhere, and what Commissioner Bloom is saying here, I do feel like 90% of these wells that will be brought back will be done within the 3.5 years. So meaning quickly, it will be done quickly. So why do you want to bond them at 150,000? Why not still under the blanket bond? And after that 2 years, then you know that probably they are getting into the threshold where they might not be brought back. And you bond them 50,000.
We flip to,
I think the answer to that, Chairman Pomo, is that more years that go out, the less likely that well is to be returned to production. So it should have a bond on it because so that way it doesn't get orphaned.
So the
It can't get orphaned, but at least there's a bond, right?
So the 2 years is still not done.
They've already had 5 years, 13 months, right?
No, the 5 years is the extension to the initial TA, right? They have to be approved, gone through the MIT before they get the 5 years. So this one is just for the transition between active and then inactive.
So I'm looking at previous, I mean, in fact, 248, generally a well that is up for TA renewal has been inactive for 6 years. 1 year of inactivity prior to going into TA, and then 5 more years in TA.
So you said 1 year inactivity prior to TA? Where are you reading that?
248.
So is that 1 year anywhere in the rule? Or is it the same as well?
Yes, because you have to apply approved TA status, right? Around the time of that 1 year.
so
After a well's been inactive for a year, you have to apply for TA status.
Yeah, so the difference is approved TA status versus in the statute, it doesn't use the word approved. It simply says TA status. And so the statute is read as inactive wells that haven't gone through the approval process are still considered TA'd for the purposes of the statute is the way. So now I don't know if there's a way for us to wordsmith this, because I'm fine leaving the 2 years in if we include the inactive period, if that makes any sense.
Yeah, then I will agree with that. And I don't think they can challenge that.
Does that make it, so if we include so if we don't count it from but the way this is written, your 2-year clock starts after the approval. What I think makes more sense as a reasonable compromise position that also then more strictly tracks or creates less confusion with the statute is if we acknowledge that the statute simply says any kind of temporary abandonment approved or other, it doesn't specify what kind of temporary abandonment. So if we simply say, if we start that 2-year clock from the day it stops reporting production, I'm fine with that.
I'm fine with that too.
Okay. But then we run into two problems. One is how we want to wordsmith that to have it reflect number one, and number two, how we want to square the various findings of fact, because we'll just have to rewrite our own finding of fact to come to this compromise position, which is fine. We'll just do that.
So, but how would we reword that?
So I guess wells that have been inactive for more than 2 years. So we'd have to move those.
Months or 14 months.
15 that you're talking about, or which
My notes say inactive, okay for 12 months, then have 2 months to apply for TA. I can't read my citation, so I'm trying to figure out where that is.
Already walked past it for sure. So. Maybe the definition of inactive well. Definition of inactive well means a well that has had no production or injection for 12 consecutive months or is not being used for beneficial purposes.
And where's the 2 months for TA? Is that in 25?
Since inactivity.
So, Mr. Chair, I don't mean to bog people down, but I just want to make sure if you've changed that reference, there's a better place to change it or whether those need to be consistent somehow. That's something I could research during the next break.
I thought I had an understanding of how PA works and how this fits together and what would be exempted and what would be included, and I'm not sure that I do.
Anymore.
Yeah. Confused on it.
Mr. Chair, so I think the language that we're thinking about here, it could be inactive wells and wells in expired or approved temporarily abandoned status for more than 2 years since expressing activity.
Would it be simpler to move the 2 years to the front and just say wells that have been inactive for more than 2 years, comma, wells in approved or expired TAs, so wells that have been inactive for more than 2 years, comma, wells in approved TA status, comma, and wells in expired TA status.
Okay, yeah, that works too. That works too. Because that one, you are not counting it from when it became TA.
You're counting it from
When
inactivity.
Exactly. That works for me.
Okay. I don't know if somebody's note taking that, if we want to write that, I'm struggling to take notes, so if somebody else also wants to.
Or it's possible to put it on a shared screen or anything like that. I don't know.
Sheila, are you at least writing down what's being proposed, sort of?
I don't have if you can repeat it,
Okay.
I don't have a very good.
That's okay.
Yeah.
I think what we suggested was that for D, or so,
I could,
well, it's F in the applicants, it's D in Namoga's proposed language.
Take this up too.
okay,
The heading, we were gonna rewrite the heading to read, or at least that's what we're considering for now. Wells that have been inactive for 2 years, comma, wells in approved temporary abandonment status, comma, or wells in expired temporary abandoned status.
I didn't get it.
So
What's changing? I'm sorry.
the whole sentence is getting a little scrambled because I'm rewriting the
The
sentence. a little
beginning
bit.
of
So it would be,
is changing.
Title.
yeah, the title.
It no longer begins with inactive wells. It's wells that have been
Wells that have been inactive for more than 2 years,
inactive. Okay. For 2 years.
comma, wells in approved temporarily abandoned status, comma, and wells in expired temporarily abandoned status. And the language in the actual paragraph after that would just want to reflect that same language of, an operator shall provide financial assurance for whatever is in the title.
Wells have been inactive for more than 2 years. Wells that are approved.
That's good.
I would be fine with exploring at least, let's hold on to that language and then just make sure that we can find sufficient evidence in the record to support that if if the commission wants to do that. But shall we at least tentatively put that on the list?
All we've done is parked everything we parked Wednesday. I'll point that out. We haven't actually decided anything. One option too, we did this during the pit rule, was reopen deliberations and went over issues that were for the evidentiary portion, I guess. I don't know if that's an option here to hear. You get a complete walkthrough of the existing structure of how inactive wells are handled, wells in approved TA status, wells in temporarily abandoned status are handled, and what would happen under the applicant's proposal and what would happen when we look at something like Namoga's proposed alternative language. Or if somebody can summarize that for me, I'd love to hear it. I'm struggling. then, Mr. Chair, you suggested that there's differences between what, actually, what the OCD actually does versus what the rule is. So that's like a fourth version.
Or, well, just that the OCD in the current rule as it exists makes a distinction between temporary abandonment without any other modifier in the statute versus approved temporary abandonment in the existing rule. That's all. We're just making, I'm just merely making that note. Not that OCD is, has a position beyond what the rule says, but do we have sufficient? I think at least as a matter of policy, we've got on the record what Dr. Mpoma is proposing and wishes to do, a compromise position that I think I could live with. But I do think that I also hear your point that you're still a little, and I'm with you to a certain extent as to being muddy as to how these three options compare, right? The applicant's position, which is joined by Oxy, the NMOGA and IPN's position, and then the revised language that Dr. Mpoma and I just talked about. So perhaps we'll have a little bit more input from legal once we've had a chance to take a break and dive in deeper. Okay.
Okay.
These are the challenging bits. The next topic that I had flagged for discussion is 1915-99D. I think this one might actually be one where we can get to because I've just jinxed us. Correct if I'm wrong, but I believe it's here. Works in conjunction with with 1915-59A4. At least that's what I thought in the middle of the night as I was trying to sort this all out. So if the commission has already accepted previous provisions in 1915-59A4, then I think we would also go with the applicants for consistency in 1915-99D. At least that's what I read myself last night. I don't know if that still makes sense to people.
So this was to, what we're talking about here is approving the deletion of the words more than the allowed number in two locations, correct?
That's correct.
That was fine with doing that as well. So I go through this seemed to fit with the rest of the rule as is proposed.
Okay.
I think it would be for consistency, yeah.
Yeah.
Okay. So no opposition to adopting the applicant's post-hearing amendments to 1915-99D.
I would so move, yes.
I second.
Without objection. Okay, or any objection? Without objection. Okay. Next on my list, and again, do stop me if I miss anything, but I have 1915-25, 5, 9.
Yes. Yes. Here, we're discussing how to, we wanted to reconsider Moga's suggestion, but you wanted us to put like a stop at 30 days and not going to be real carrying.
Right, sorry, 25.9.
What I? 1525, no, 1915-25 9D is what I have written down.
Looking at Namota's language there.
Yeah.
These two things are,
We're talking about Namoga's additional language, proposed additional language, say upon request by the operator, the division may use its discretion to grant an extension of the 30-day rebuttal period for this cause.
find all the rope. We're looking at 9. Right, or what would be, what is proposed is 3 in the applicants and then what is struck
I
out?
don't know, I think in the Moga's version, the alternative language, their language, for D, we see the inclusion of an extra 30-day
Oh.
period.
I mean, that's just an extra 30 days.
Yeah.
I would be fine with, I'm not too worried about that.
Yeah, I think you wanted to reword that to stop right at 30 days.
No, well, that's fine. I think as long as the word "and" is in there and so that's only one extension, it's not gonna be a rolling continuous forever extension.
Yeah,
That's right, that's what you said.
Yes.
Yeah, and I would just note that here in this language, we need to insert the word "to" between discretion and grant.
That's right.
To grant, okay.
Yeah. I'm going to highlight this green language. Sorry, now I'm gonna have more colors. I need a way to track what we're adding.
That was quick.
Did we talk about sub 3 already? And was that okay? D sub 3 and 4? Wasn't sure whether that was needing revisiting too.
I think we're okay with that. It's the,
Yes, I believe we went through that, and those were some of the extra criteria that, like, if we're looking at Namoga's language here, they wanted to strike having to potentially turn over information on capitalization, things like that.
But it already says may, so they don't have to anyway, right? So we just left it in as proposed by the applicants because it's merely an illustrative list, not a mandatory list.
Yeah.
Okay.
oh, you remember that?
That's right. Oh, that's true
Yeah.
too. Yeah.
Yeah, that was perfectly what you said. Yeah.
Sometimes I have consistent thoughts.
For sure.
I don't promise that it's all the time, but sometimes I try. Okay. 1915-25-13 C2 is what I have next on the list.
Yeah,
We're getting into those issues of, can any interested person take part in hearing
Yes.
TA extensions, and does TA extension hearing
Just give me one.
need to be published for 30 days in a newspaper of general circulation?
Just give me 1 second to flip through it so that I have it in front of me.
I didn't get there too.
15-25-13 C.
It's Oxy's page here, last one.
Oh.
Yeah.
Moga adopts what Oxy says, but it's easier to read off their page. Yeah, every last page.
So I don't have, but if I did have that, it's lost to the ether. Well, maybe I don't have it yet.
So I'd ask for some more time, so I'll quickly give you some advice. So the first sentence that Oxy wants to strike is the newspaper. They say that's rarely done. That's incorrect. In both rulemaking and your rule adjudication rules, you do require notice by newspaper. Now you have a policy question. Do you want it on this one or not? So you have flexibility, but there is precedent for doing newspaper. Part two, about the interested person. And there actually, I agree with Oxy's argument that term is not used in your rules as existing. And their language, I think, is more consistent with your rules as is.
Yeah.
And let me just say, the applicant said, well, we're going to use language from the Water Commission Act. I don't find that persuasive.
Okay.
So, and yeah, thank you, Mr. Chandler. That was helpful. I was looking at the applicant's closing statement, finding a fact 257. Initially, applicants proposed that renewal of TA for 2 years must be subject to a public hearing. As a result of negotiations, applicants proposed that a public hearing before OCD can be held upon request by the OCD, the operator, or an interested person if an operator applies for an extension. So the interested person, we've gone from a required public hearing as a result of negotiations to one where the OCD and operator or an interested person can request an extension or request a hearing, right? So I think that's a little different than just saying interested parties are included, to be included in hearings. They can request one. And, if we don't have interested person, this could be, for example, a situation where another agency, say the land office, wanted to request that hearing as an interested person, right? So interested person certainly covers those other entities.
But in this case, the state lands office would have standing to do that.
As an interested person.
Yeah.
Yeah.
Will have standing, but not, let's say, a professor from New Mexico Tech who wants to argue about this.
Or worse, somebody in a nursing home in Australia who was just very bored.
Yeah.
Right? Like, it's very, or whoever you can think of around the world. So I do agree that we need to narrow it into I think even standing is really broad, but I definitely think that any interested person is too broad. But to address the concerns about the state land office, making sure that the state land office would be able to intervene. Once you get to a hearing, because it does go on to say that the normal hearing rules apply, right? And so our existing,
So it would be standing for a landowner. Yeah.
well, yes, and beyond that, there's language in our existing rules that says that the division examiner or the commission chair it says may strike if they fail to demonstrate standing unless the intervener shows that the intervener's participation will contribute substantially to the prevention of waste, protection of correlative rights, or the protection of public health or the environment. In my view, I would be surprised if the state land office wasn't able to demonstrate that it has something substantial to contribute as it relates to the prevention of waste and protection of correlative rights, protection of public health or the environment. So to a certain extent, yes, you would be relying on future division examiner and commission chair's discretion on who to confer this more discretionary standard for intervention.
And I would just again flag, I want to talk through some of the other items that were mentioned by the applicants, and that was hearing from interested parties may provide additional information and valuable insight into perspectives to assist OCD in understanding potential impacts of TA and making an informed decision. This will allow public participation at critical points in decisions, provide greater transparency. And number 260 goes on to say that interested persons may participate in a permit hearing under the Water Quality Act. And we also have any person can participate in a permitting hearing before NMED under Air Quality Control Act, Hazardous Waste Act, and Solid Waste Act. But other areas where people can be impacted by a source point, they can participate as an interested person.
Sorry. But but you were also talking people with standing, right? So the question is, do we limit to people with standing only or anybody who is just remotely interested? Feels
So
interested.
you feel that the current language that we have would allow somebody to intervene if, say, they were a neighbor to a site, was up for a renewal?
I think because it says other person withstanding, and I think that, so I'm not worried about standing being too narrow. If anything, I'm worried about standing being too broad. Because somebody could argue that whether or not they prevail, I could see somebody coming in and say, I live in Farmington, but I won't think I should have standing to contest TA status of a well in Hobbs because it impacts climate change, which is global, right? Those are the types of arguments that I think the commission is going to struggle with. I think the commission is I would be very surprised if the commission somehow were to take the position that even an adjoining landowner didn't have standing. I'm more concerned about somebody from not even here, right? So an NGO in New York who is concerned about something else, basically taking
Methane emissions. Yeah.
right, methane emissions, taking every single TA extension to a hearing and bogging down the capacity of our commission to take those things on. So having thought about this last night on there's two different points here that Oxy makes, and I broadly agree. I think I lean towards Oxy's amendments. As much as I personally support small newspapers and independent journalism, I do think that it is certainly within our I think right to if that is a matter of policy that the division wants this noticed in the newspaper. It is, to Dr. Mpoma's point, and I think I said this on Wednesday, newspapers are a more and more old-fashioned way of trying to get information out to the public, and there are better, more targeted ways to ensure that we reach the right people with the right information. If anything, advertising on Instagram or TikTok is probably more effective than advertising in newspapers at this point. So I can see that there is I can see that this is common in statute, but I also see Dr. Mpoma's point that it may be more old-fashioned than it provides actual functional help.
I just heard you say you're going to take those notices to TikTok. Facebook Reels.
Facebook Reels, yeah.
I want to see the dance.
You want to see the dance, right? Operators are required to do a TikTok dance notification. And for the record, that was humor. So I'm fine with accepting, and I would recommend that the commission accept both of these, or the entire proposed amendments from NMOGA. I'm sorry, from Oxy. I apologize.
Yeah, I do support that.
I believe I'm in support. I think if we had interested persons, people that want to participate can participate, and now we might have arguments about who has standing coming to the OCC.
True.
So, it's going to be perhaps too open, create some issues for the hearing officer. If it seems to be too closed and it creates disputes around standing, and we have some standing issues in front of us.
True.
Right now at the OCC, those come to us. So I'd rather be, I guess, more inclusive. So I'll be the odd man out on this one.
So if it makes you feel so, I mean, I think you summarized the same issue. Those are the choices in front of us, right? Completely wide open door where we don't have the ability to say, I'm sorry, you're just too tangential, versus at least giving the commission and or the hearing examiner some ability to say, okay, you're disrupting your presence here, you're not this is too far removed that we're not going to let you initiate all these cases, versus not having any standards at all. To the point about having a bunch of standing disputes, I agree with you that I don't love those either, but I feel like having some standards if we need to, having some gatekeeping mechanism if we need it is better than having no gatekeeping mechanism to be able to run it all. I think, I mean, it's fine at the end of the day if it's a split vote. I respect, that we are all independent thinkers here. I'm also happy to take that as a tentative vote and to come back and revisit at the end just to see if it changes anybody's opinions. So, or you know what, how about we do it? We'll take it as a split vote for now, but I'm open if you want to raise it for reconsideration at the end and revisit.
Thank you.
So at least for the record now, Dr. Mpoma, do you move that we accept OCC's amendments?
I so move.
I will second, and I will take.
One
vote
nay.
against,
Yeah.
One nay. So one Commissioner Bloom opposes for the record. And votes in favor, Commissioner Mpoma?
Aye.
Vote in aye. And I will vote to break the tie in favor for the moment, though I'm happy to reconsider throughout the day. Okay,
I think there's number 5. From the Milga.
so. Still on, I'm sorry.
C, still on C. There is number 5 that we pinned down.
Oh,
That's right.
2513C5.
Yes.
Yeah.
Yes.
Oh, just let me get there 1 second.
This gets back into the murky world.
Just like cramp.
Wow, for me on the leg table on chest.
As I was researching this last night, I found a couple of the closing arguments speaking to this. So the applicants, it was pages 71 and 72, starting with finding of fact 236. And then the MOGA was their finding of facts 110 through 13. We just take a few minutes to reread those. Like they said now, just looked up them last.
You know what, just so I have notes as well, would you repeat those sections?
Sure.
Just so I can-
Yeah. Okay. So the applicant's closing arguments, pages 71 through 72. This includes findings of fact 236 or 240. And then roughly, and then Namoga's findings of fact 110 through 113. to be able to get second 5-year extension instead of a 2-year after the 5 years.
So it's just delaying the number of years to come back. And reading through this,
For sure.
I will not actually support this, because it's just prolonging. So Nimoga is saying that instead of the 2 years request, we should extend that to 5 years, not 2 years, right? So extend it to more like 3 years 3 more years before they come back. That would be more like pushing it out. So I will not support that.
Commissioner Bloom.
I think some of these points I actually mentioned were ones I mentioned in the previous discussion about exemption of the 2 years from bonding.
This one, you already have the 5 years.
Yeah.
And then you are coming back.
Yeah.
So the current that we're working on is saying you can only get 2 more years. And then you can come back for 5. But Yoga wants us to take away that 2 years, make it 5 years.
Yeah, yeah.
So it's more like extended for.
Yeah, I agree. That's too long, so I would
That's
not
too long.
be
Yeah.
supportive of that, of inclusion of this additional thing.
Okay.
Move to not adopt that language.
I'm sorry, I was just gonna add that the applicant's exhibit 3 did show that the likelihood that a well would be put back into productive use after 8 years of inactivity is almost non-existent.
Thank you. You had a motion.
Yeah, so I would move to reject Namoga's proposal at the 1915-25 C5.
And I second.
Motion and a second. Any objections? Without opposition, so adopted. Or so declined to adopt. The motion is adopted. The motion to decline is adopted, yes. Okay. Unless my notes are incomplete, it looks like I only have one last issue before we have to go back to and look at the stuff that we need to revisit after lunch. So I have 19, 15, 25, 13. Let me start again. 19, 15, 25, 13, C5.
We just did.
Oh,
That was.
I just have it written down twice. Okay. In that case, I don't show any other visions that we haven't discussed.
Which ones did we park?
We go back to double bonding momentarily.
I was gonna do that, sure, but then I was gonna give us lunch to think about it and then come back and.
Okay,
Do you have some guidance? Or anything else?
I was just gonna tell you what I found
Yes.
and then you can take it up after lunch.
Perfect.
I have a question too for both of you that I don't understand, so I think it'd be helpful to reflect on that.
So, excuse me.
So just the context, this is the second one that you've debated. This is 1915A9A, the very last part where they want to not double bond.
Right. So IPA&M and NMOGA both address it and both propose the insertion of the language that's just referenced. NMOGA addresses it on page 15 of its closing arguments. This is section H. The potential double bonding problem across OCD regulations should be fixed. They mention a second form of double bonding, which has already been briefly raised this morning, that the rulemaking we did the hearing for last week, which does not come to an end at the State Land Office, is a second possible double bonding issue. So that one, let me just address that really quickly. So the federal leases can be considered in the rules. that state, financial assurance associated with state leases should also be considered. So that's their proposed fix. As to the anticipated state land office. As to the double bonding issue within the proposed regulations, again, there's discussion in section H, starting on page 15. There's discussion on page 63. This is the proposed findings, beginning with finding 65. And then there's also discussion on page 57 in the proposed findings between 34 and goes into the 40s. So what they're pointing out is that as proposed, if a well is bonded under the sections that have been referenced here, 1915, 8, 9A, and then you go C through G, that a bond might be required both as a low producing well and, for example, as part of a high risk portfolio. I think
That's the example I gave, yes.
you described that earlier, Commissioner Bloom. The applicants, I didn't see a place where the applicants disputed the possibility of double bonding. But what they would focus the commission on in their closing argument is that low producing wells really are high risk wells, highly likely to generate only limited or negative profits, increasing the risk of orphaning. That the proposal for financial assurance for producing wells, it creates an important incentive, which prevents waste and protects correlative rights. It incentivizes them to avoid incurring additional financial assurance by plugging them. And they also point out that low producing wells constitute just 6.6% of the well population and 0.048% of total production in New Mexico. And they do cite to their exhibits there. Wells provide exceedingly low economic utility to their owners or the state, but pose a high risk of being orphaned, requiring state resources to plug. So that's the nature, I would say, of their support. And the only other thing I guess I would point out from their arguments here, I said what pages those were, between about pages 36 and, well, continuing at least until 40, starting with, the findings I was looking at was like 115 and continuing. The other thing was, as a result of the post-hearing negotiations, they did delay implementation of the financial assurance requirements for low producing wells to 2029. They did push that out, but again, they would like to incentivize plugging.
Sure, seems to be the motivating underlying motivation.
Question, why would G be one of the factors that would be included? Why is that included in the suggested language to avoid double bonding?
Well, they may have meant the old sheet. I mean, there's a fair amount of relettering here.
Or, let's
Pretty
see.
sure I saw that.
The MOGA's, let's get the MOGA's draft. And get there.
IPA&M's proposed alternative language is fairly easy to read as well on page 8 of 13.
Okay, so I'm sorry, just sticking with the notes for a moment. I look at page 21 with their language, projected language. You see, it says, the subsection A applies to subsections B through H in satisfaction of any one of subsections C through G for a well satisfies the operator's plug-in financial assurance for that well. So I go down to G and it says, oh, there's G in their version. So
The relettering might have
yeah.
introduced some confusion.
So if I were to look, the applicant's suggested language, G. Oh,
There is no G.
the applicants have one, but it says, the proposed one, the joint stipulation says, operators who have on file with the division of blanket plugging financial assurance, it does not cover additional well files, file additional one well plugging financial assurance for any wells not covered by the existing blanket. Plugging financial assurance, the amount is determined, et cetera, or may file a single instrument. So I can't imagine why that doesn't seem to be bonding anything, why that would be exempted. And otherwise, I don't know, that's the only G around. And so I don't know why Moga's suggested language would state that, and I'm not sure we can include that section in any sort of carve out.
IPA&M also said C through G. But again, there might have been confusion introduced.
Yeah, there's confusion, that's for sure.
From all the renumbering at the very minimum.
That's all I had to say. Obviously, that's
Stuff that, so I need to make a new list. If somebody could help me make a new list of what remains to be debated, because we definitely have for this afternoon. I have 19, 15, 8, 9A.
That's this one.
Madam Chair, was the double bonding issue raised during the evidentiary hearing, as you recall? Or did it come up more as we got into
I think when,
closings?
okay, so I don't remember evidence of double bonding, say, from IPA&M. It's looking at the face of the rule. I think they're pointing out something that.
Yeah, but I agree, and I think that's why the applicants don't speak to it either, because it wasn't something we discussed. The one that I'm talking about, this double bonding, is because of the structure of the rules. We did have a conversation about double bonding with a potential land office bonding of its leases, which is different because it's up to $150,000 per lease. You know, it could be 6 average wells on a lease, so actually much lower, but neither here nor there. But just in dealing with this, I don't. The language in 8.9A, I just don't really believe we saw it then, so I just want to be sure of that.
We resolved 19, 15, 8, 9, D3 and D3E from Namoga.
That was 1, 2 that we wanted to come back to.
Okay, so I will 19, 15, 8, 9, D.
E is in boy or D is?
D
is
D3. Yeah.
All of,
I need to find if there's anything in record about fracturing, stimulation, drilling, or operation.
Yeah.
That one was, yeah.
this is yet another where the numbering is very odd for me because 9. E. Yeah, okay. Okay. Also D4 before. D4, I think we have a concept, we just need to write it out.
What was
right?
D4 again?
Variance, I think.
It's the 30 days.
Yeah.
The deemed, I just needed to add that it would be a deemed denial and they'll have to take it to a hearing.
Yeah.
Otherwise, it's too much. So I'll put that down here, but I think that'll be an easy, well, that just requires a little bit of word, new language. Okay. 1915-89 F. Did we resolve that?
Yes, state.
That one's resolved.
We,
Yeah, he provided a language. So he said we wanted to cross check.
Yes, so
yeah, I don't think I agreed to that.
Troublemaker.
Yeah.
So wait, that's not right. I'm looking at financial, I must be looking at the wrong.
It was the inactive.
That's inactive wells and wells that expired or approved temporarily abandoned.
Yeah, it's
Within 2 years.
Yeah. So that was where, and we can come back to it and revisit, but I had a soft proposal for us to consider with, wells that have been inactive for more than 2 years, comma, wells in approved TA status, comma, or wells in expired TA status.
So 1915-25-8 is the rule I was looking for, specifically E3. So that is titled Wells to be properly abandoned. 1915-25-8B. So that says an operator of a well shall plug. The operator shall either properly plug or abandon a well or apply to the division, place the well in approved TA within 60 days after a period of 1 year in which a well has been continuously inactive. I need to spend some time aligning that with the 2 years to figure out the sequence that Commissioner Bloom wants determined.
Where's the 5 years come in?
I believe that is once you have been granted, then that's an extension upon it. This is, I've just gone from active to inactive.
Already 1 year.
Commissioner Mpoma says, well, there might be good operators that are just going to let things fallow while they figure out a secondary recovery system. Or there could be bad operators that are already on the path to problems. So that's the time sequencing I need to figure out, because Commissioner Mpoma is uncomfortable this time automatically kicking someone up to the possibly higher bond.
Was it 1 year? You have 13, 14 months between active to inactive. And there's an application for temporary abandoned status at that point. Is that initial period 5 years or 2 years?
I think it's 5 years.
I thought it was 5 years.
Yeah, 5 years.
Yes, so under 1915-25 new 13A, the division may place an approved TA for a period up to 5 years.
5 years.
And there's a 2-year extension and another 2-year extension.
The 5 years. And then the Moga was looking for 2 years. But
So under the new 13B, they talk about 2 years. And then C talks about 5 years. So there is some sequencing to work out here.
so Zach, yeah, can you help us? I mean, reconcile the 1915.25.8 to the F that we are trying to resolve.
Yes, I'm trying to make sure that there's internal consistency
Okay.
to fit on PO.
May I suggest a lunch break at this point? And I know I don't think that's it, right? I've looked through it. Everything else we've managed to resolve one way or the other. So all we are is, if everything is in 1915-8-9, it's just various subsections there. So we're getting to the crux and the heart of the rulemaking, which is good. May I suggest that we take a lunch break until to give ourselves more time to actually look through the issues, 1:30?
Yeah.
Okay. In that case, we are in recess until 1:30 p.m. Thank you all.